All important transactions with respect to immovable property are to be registered as envisaged in the Registration Act. The copies of all registered documents are retained in the Sub-Registry office. Certified copies of almost all registered documents are available even to strangers of the documents. Prospective purchaser can avail the details of title, interest and liability over a piece of land by applying for encumbrance certificate before the Sub-Registry office. It is considered to be the most reliable information. So every change on title, even if resulted from court verdict, has to reach the Sub-Registry office promptly. This ensures that all transactions are accurately recorded and legally binding. There are the key procedures for registering such changes at the Sub-Registry office, especially when these changes result from court interventions. When a court decrees specific performance of a contract involving immovable property, the defendant is expected to execute the sale deed. However, if the defendant fails to do so within the stipulated time, the court may intervene and execute the sale deed on their behalf. The process involves the judge signing the sale deed and authorizing a court clerk to present it for registration. This procedure is authorized under Section 88 of the Registration Act. Consequently, the sale deed is registered and all relevant details are made available at the Sub-Registry office. In cases where a final decree of partition is issued, the decree must be engrossed on non-judicial stamp paper based on the court's valuation. The concerned party is responsible for providing the necessary stamp paper. Once the final decree is engrossed, it serves the same purpose as a registered partition deed. The court then forwards a copy of this final decree to the sub-registrar, who records the allocation of shares. Notably, the parties involved in the partition do not need to appear before the sub-registrar to provide thumb impressions. This process is detailed in Rule 237(2) of the Kerala Civil Rules of Practice. The civil court has the authority to cancel registered documents if there are sufficient grounds. Upon doing so, the court must send a copy of that decree to the sub-registry office where the document was originally registered. This requirement, outlined in Section 31(2) of the Specific Relief Act, ensures that the cancellation is properly noted in the registry, maintaining accurate records of the property's legal status. Immovable property can also be sold through court-ordered public auctions, typically in execution proceedings. After completing the necessary formalities, the court issues a sale certificate to the purchaser once the sale is finalized. This sale certificate acts as the title deed for the auction purchaser and must be sent to the sub-registrar by the court. Unlike other transactions, this sale certificate does not require further registration. This process is governed by Order 21 Rule 94 of the Civil Procedure Code and Rules 345-346 of the Civil Rules of Practice. These procedures are designed to ensure that all significant transactions and changes concerning immovable property are accurately recorded in the sub-registry office. Whether it's the execution of a sale deed by the court, the issuance of a final decree of partition, the cancellation of a registered document, or the sale of property through court auction, the law mandates that these changes are promptly communicated to the sub-registrar. This meticulous process upholds the reliability of property records, providing clear and legal documentation for all parties involved. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.